and artificial intelligence would be, I have a pretty wide portfolio. Economic development at 600 weeks, economic center Runkinsdale, economic development, workforce development.
Okay.
Yeah. But why tech?
That's good. Just curious.
Yes. Yeah.
So we're all okay.
So S227, and Mr. Chair, do you want me to share my screen or just I'm happy either way?
It's posted. Yeah.
Okay, so I think
As introduced.
we all have our copies.
Okay. All right. And you know, it's kind of big picture here, S227. Admins Title 16, which is what this committee is familiar with. Chapter 33 currently has some language about the fire and emergency prepared drills, safety patrols. And this bill would add in some immigration protocols for schools to adhere to. So we have some definitions. We define a federal immigration authority on the bottom of page 1. That is a federal agency or department, along with their employees, tasked with enforcement of immigration law. And that includes DHS, Department of Homeland Security, Immigration, Customs Enforcement, ICE, and the Border Patrol. Number 2, non-public area of a school site is kind of as it sounds. It is an area of a school that normally requires authorization by the school to enter, consistent with Section 1484, which, if you're not familiar with that section, that is your access control and visitor management policy that every school has to have. Includes classrooms, the cafeteria, the gymnasium.
Quick question. When it says non-public areas, will that also include law enforcement? Are they subject to the non-public areas, or are they automatically, being that they are part of the government, that they are allowed in a non-public area?
So it depends, and we'll get there. Okay. As far as when it actually, how we use that definition.
All right.
Yeah, it's because I can't say yes or no because it doesn't.
This is still a definition.
Right.
Right. Yeah, okay.
So classrooms, cafeteria, gymnasium, playgrounds, and any other location where students gather. So really, if you think about it, most schools have that lobby where even today you have to get permission to enter because the doors are locked. Number 3, school means a public school or an independent school approved under Section 166 of the title, and includes employees and independent contractors working for the school. I'll add that Beth St. James, you're very familiar with her. She looked at the bill and helped me put up these definitions. And she might need to come in if you have questions about specifically school definitions. Subsection B, each school district an approved independent school in the state shall adopt and maintain a policy that reflects the requirements of this bill. Each superintendent and head of school shall develop and implement procedures to carry out such policies. Subsection C, immigration resources. A superintendent shall distribute immigration and civil rights related resources to staff, students, and family members that are provided by the Office of the Attorney General or by another source that has had its resources reviewed and approved by the Attorney General's office. Also, each school the superintendent oversees, they shall designate an officer to serve as a resource for immigration-related matters, who shall receive from the superintendent updated information on an ongoing basis. D, guardian detainment. A superintendent or their designee shall, to the greatest extent possible, partner with a legal advocacy institution that will provide assistance to a student in the event that a guardian of a student has been detained by immigration authorities while the student is in school.
So what is that? Let's just look at that.
So I think that the reason the language is to the greatest extent possible is because not every school may have the ability to partner with such an institution that can manage those types of events. So the language is meant to be a bit flexible, to where some school districts, some schools may be easily able to partner with a legal advocacy group that could do that, but some schools in rural Vermont may not have that same opportunity to do that.
So in some ways, it's just making sure that there's somebody to call if something happens to get jump in and provide. So
These legal institutions you're thinking about, they don't have to be lawyers, but they should know immigration law and should know how to best facilitate that. Yeah. Student records, subsection E. School districts are prohibited from using policies or procedures to engage in practices that have the effect of excluding a legal pupil from school, including collecting or requesting information regarding citizenship or immigration status of students or their family members, except as required by state or federal law, or as required to administer a state or federally supported educational program. Prohibited from designating immigration status, citizenship, place of birth, nationality, or national origin as directory information, as those terms are defined by FERPA. Voluntary sharing from student information, including immigration status, citizenship, place of birth, nationality, national origin, sexual orientation, status as a survivor of domestic violence or sexual assault, status as a recipient of public assistance, or school discipline records with a third party, unless required to do so by state or federal law. Those are the record requirements. F, immigration authorities on site. The superintendent of a school shall, subject to an exception below, be the sole authority to admit a federal immigration authority into a non-public area of the school site, and designate one person that works at each school to serve as a designee of the superintendent in the event that they are not present when a federal immigration authority appears on site. The superintendent or designee shall not allow a federal immigration authority into a non-public area of a school site unless a judicial warrant is presented by the authority that names a specific individual under arrest or subject to a search. In the event that the authority enters that non-public area without approval, the school shall not obstruct the authority from entering a non-public area of the school site.
So let's just make sure we understand what that says. So it says in the first instance, you don't let them in unless they have a judicial warrant. Then B, if they break through the door or whatever, you don't get into it.
Right. For absent a judicial warrant, no school shall reveal any information about a student or school staff member in response to a request from a federal immigration authority. And then
Just a quick question, is any of this already in statute?
there's not in statute. Some schools have their own policies. I think Winooski
Okay.
is a big common one.
So we're kind of pulling all the policies together in this one bill to settle policy.
That this would kind of be, this would be a state statute, and every school would have to adopt a policy that reflects the statute. Correct. Top of page 5, immigration agreements. Except as required by federal law, no school shall enter into an agreement with a state, local, or federal government entity that furthers the enforcement of any federal immigration law. The school superintendent is the sole individual that may approve an agreement required by federal law. Any questions about that? The first section. Section 2 is the Immigration Resource Guide that was referenced earlier. So the Office of the Attorney General, in consultation with the Agency of Education, shall develop an immigration resource guide pursuant to that section earlier in the bill. The guide shall be developed in a manner that serves to protect the privacy and safety of students and staff. The guide shall be completed on or before March 1st, 2026, and be sent to all superintendents for distribution to school districts on or before March 31st, 2026. The office shall review the guide at least once annually and send any updates to the guide to all superintendents not later than 30 days after completion of the guide. And then the policy adoption deadline. Each school district and approved independent school subject to the requirements of the act shall finalize a policy pursuant to the earlier in the bill where schools must adopt a policy that reflect the statutory language here on or before August 1, 2026. So the question earlier about the non-public area of the school site, just to kind of circle back to that question. It is a officer, federal immigration officer without a warrant. No, However, if it's state police, yes, or any other police, without a warrant, they're allowed to go into the non-public area of the school site, assuming they meet the current access control that a school has developed per policy for statute 1484. If the person's allowed in through that policy, then they would be allowed in. So that's kind of what the statute would do is in regards to non-public areas of the school. Effective on July 1, 2026. That is the bill.
Yes.
So is there the federal law that's referenced in here? Is that contrary to what we're trying to do?
So there's just in general federal laws that apply. Like the Immigration Nationality Act is one immigration law that is a federal law. So the purpose is, instead of naming every federal law that could contradict this, is saying that if there is a federal law that would provide a way to get records of students, in that federal law supersedes state law, because we cannot go against federal law. So in this case, it's saying that unless there's a federal law on point, this state law should be what schools follow.
What does it mean on page 3? This is the student records section. It says on line 9, have the effect of excluding a legal pupil from school. What does the term legal pupil?
So my understanding is the Vermont Constitution provides a right to education, right, for all individuals. And the language there is intended to make that clear that if you have a kid in Vermont, they have a right to an education.
Because by virtue of the fact that they are here, right? Yeah, correct.
So we can rephrase that if you think something else. I'm also going back to my mind with draft list.
Yeah. So a legal student really is anybody who's here, which
Per the Vermont Constitution, right?
Yeah. Okay.
I think there are other federal laws that support, like McKinney-Vento supports that a student doesn't have to be a citizen or have a residence in that district.
The federal constitution, I think, is also fairly clear, but I would cite the Vermont Constitution as well, as being the more immediate thing that you can look at and see that Vermont itself requires it. And the federal government as a constitution as a form, also, I don't think guarantees the right to an education.
Right, just if there's a conflict, and the AOE guidance also cites multiple federal laws, which I think is important if two different entities are arguing about who has authority, as we've seen.
I just wanted to make sure what anybody out. Yeah.
They can be approved.
Now I get this section.
And perhaps that language could be adjusted.
No,
I mean, absolutely.
So one last question for us, I think. Well, we should discuss some testimony. Obviously,
The superintendent.
superintendents, the AG, and perhaps the agency.
Probably principals. Because our schools are not gonna have superintendents, so it's probably gonna be.
Well, they all will have. I see what you're saying. They all will be under a superintendent.
Yes,
but not the
but he's supposed to be there, so
Yeah,
if it's my
yeah,
school and he
yeah.
can't be there.
And so we want to think about whether we want somebody to be responsible for a login policy. That doesn't quite say that here, right? Theoretically, each SU or SV would have to come up with their own.
each school district and approved independent school in the state shall adopt and maintain a policy that reflects the requirements. So there's some flexibility as to how they word things, but in general, you have these framework that the statute provides you.
Although perhaps you're suggesting it might be helpful to school districts if they had a model policy which they could build. Okay, well, that's a question. So, what's temperature check? People interested in taking this one up?
We'll see where it bumps into 209. Let's start. I don't want to duplicate reviewing bills.
Did you do 209 too? Okay.
Would it be easy enough to incorporate the two?
I think incorporate, I would need to know kind of what your, like the same exact language and make it one bill, or I think, I guess it's a matter of this is germane to the 209 and, that's not a question for me.
Right.
They're both immigration related, but I can't speak to that.
Yeah, that's what I'm working on, that's immigration related.
So 209 though is different in that this one is about the district or the SU developing a policy for what happens when and if. And 209 is very much just saying thou shalt not to.
Engage in civil arrests
So
on a longer list of places that are considered schools. And it goes to beyond places that just have superintendents. So college campuses are on there, pre-K is on there, daycare centers.
Could this fall in there fairly easy as its own?
So I'm not sure. I think, I think that it could, but it's also, I don't know if it is necessarily duplicative with the specific sections, because this is just. This is a blanket prohibition on allowing. Well, actually, I should ask the pledge council. How do you think, is there a conflict between these two? Are they redundant, or do they cover different bases?
So S209, just for everyone's reference, is a bill that restricts civil arrests in sensitive locations, which, as the bill is being worked on, includes several different things like certain government buildings, schools, and healthcare facilities. So a civil arrest is a arrest that there's no judicial warrant. It is usually an administrative warrant that a DHS employee has written and provided. So in that case, this bill also requires a warrant to enter a non-public area of a school. So they don't really conflict. What this bill's doing is really more procedural. Like, when this thing happens, here's what you do. S209 is like, just don't do this thing. Don't commit a civil arrest. This bill does not speak about civil arrests.
So the other way to think about it perhaps is that S209 is geared toward them, agents and what they can and can't do. And this is geared toward what you do if you're on the other side of it.
It's literally telling the superintendent that, to stop.
Yeah.
An immigration authority, right? So in that way, you're correct.
Yeah.
One way to look at it.
Okay.
That makes sense.
Well, why don't we take some more testimony? That you can think, well, you're gonna have, this is gonna end up with you. This is gonna get with you.
Yeah, I think we're more in the realm of dealing with the very narrow road that we can navigate of telling law enforcement,
Right.
not just federal agents, law enforcement, what they can or can't do. Whereas this is, like Rick said, telling the superintendent what they have.
Okay.
I think Rebecca Callahan at UVM in the UVM Department of Education would want to testify. She does a lot of work that is at the intersection of immigration and English language learners. But I do think this is an education policy question, even if it ends up with pass through or something in judiciary.
Oh, I think it is too. It's
Okay.
gonna go to judiciary.
But I think maybe education experts
Yeah,
would be.
well, I'm thinking superintendents, AG, agency,
Did you wrote Rebecca Callison down? I'll send Daphne her.
so. Good. Any other questions? Council? Thank you.
I think, Wilmer Echeverria would be a good superintendent to have in on this if he feels
That's the
comfortable.
super.
Winooski. Yeah.
Okay. Yes, that makes sense. Okay, thank you.
Yeah, I see no.
Okay, so I think we are with that, we are adjourned.